Hey everybody, Steve Schwinn here. The Supreme Court recently issued a huge decision on Congress's authority to subpoena private financial information from the president. The case is called Trump versus Mazars. In this case, three different committees of the U.S. House of Representatives issued four different subpoenas to private financial firms, Deutsche Bank, Capital One, and Mazars, seeking President Trump's personal financial records. The subpoenas were a little bit different from committee to committee. They sought somewhat different information, and they were designed for somewhat different purposes. After the committees issued the subpoenas, President Trump sued Deutsche Bank, Capital One, and Mazars to stop them from turning over the material and complying with the subpoenas. What President Trump argued was Congress lacked authority to subpoena this information. President Trump argued that if a committee is going to ask the president for personal financial information, the committee needs to meet a heightened standard. What President Trump meant was the committee would have to demonstrate a specific need for the information and show that it was demonstrably critical to the committee's lawmaking function. In making this argument, President Trump tried to leverage executive privilege. Executive privilege is a privilege that a president can assert to protect high-level Oval Office communications between high-level advisors and the president, him or herself. The Supreme Court flatly rejected this argument. It said executive privilege is designed to protect high-level Oval Office communications with the president. It has no bearing, it has no relevance when Congress is seeking the president's personal financial information. But on the other hand, the court said we're not playing by the ordinary rules either. Ordinarily, Congress has the authority to engage in investigations to further its lawmaking function. This means that Congress's power of investigation is quite broad, but there are some limits. The court said, as an initial matter, Congress can only engage in investigations that serve its legitimate lawmaking function. Moreover, Congress cannot engage in investigations of individuals solely for the purpose of releasing private information. Again, Congress's investigations have to be tied to their legitimate lawmaking functions. And finally, congressional investigations cannot spill over into law enforcement. They really must be tailored to Congress's legitimate law-making authority. To the extent that investigations spill over into law enforcement, Congress could be impermissibly intruding on the enforcement powers of the Article II executive branch of government. So the Supreme Court said, on the one hand, we're not going to accept this sweeping claim of executive privilege and the president's attempt to shoehorn executive privilege into this situation. But on the other hand, we're not going to accept that when Congress subpoenas the president's personal financial records, the subpoena should be subject to the ordinary considerations of any other congressional subpoena. The court recognized that when Congress subpoenas the president's personal financial information, important separation of powers considerations come into play. So how do we balance these things out? Well, what the Supreme Court said is in evaluating a congressional subpoena for the president's personal financial records, the courts need to consider at least four different things. First, the courts need to consider whether Congress actually needs this information from the president, or whether Congress could get the information from some other source. Next, the court said that the subpoena has to be narrowly tailored to get just the information that Congress needs to serve its legitimate lawmaking authority, and no more. Third, the Supreme Court said that lower courts should be attentive to Congress's stated need for the information and be sure that it's designed to serve Congress's legitimate lawmaking function. And finally, the Supreme Court said that lower courts should pay attention to whether the subpoena imposes a kind of burden on the president that would undermine the president's ability to do the president's Article II law enforcement functions. The court said that there may be other factors as well that the lower courts would want to look to in assessing Congress's authority to issue these kinds of subpoenas. What the court said is we really don't know because we don't really hear these kinds of cases every day. The court acknowledged that in most instances, the political branches come to some sort of accommodation and work it out on their own without the involvement of the courts. And the Supreme Court said, as a result, we just don't have a lot of practice and experience and law on this. So there may be other factors out there too. Okay, so what does all this mean? What it means is the case is going to go back to the lower courts to do a kind of do-over on this, and Congress will have an opportunity to justify its subpoenas in terms of those four considerations that we talked about that the Supreme Court told the lower courts to use to evaluate congressional subpoenas. Alternatively, or even in addition, Congress could issue new subpoenas that are more tailored to those four considerations. Either way, it may take some time for these cases to work their way through the courts, so it's not at all clear that Congress and the public will get their hands on President Trump's financial records before the 2020 election. But getting our hands on President Trump's financial records is just a wee little bit of this case. The bigger picture is the separation of powers picture. And what the court said in the case is that Congress indeed does have the authority to issue a subpoena for the president's personal financial records, and it flatly rejected President Trump's aggressive claim to the contrary. What it said was when Congress does that, we need to pay a special attention to those four different considerations and maybe some others, because when Congress subpoenas the president's records, well, that raises a special separation of powers concerns. I hope this has been helpful. I look forward to seeing you next time.